In 2017, the Nova Scotia Barrister Society found Lyle Howe guilty of professional misconduct and professional incompetence. As a result, he was disbarred and no longer allowed to practice as a lawyer. Howe, who is black, claimed the process was tainted and motivated by racism. The Supreme Court previously dismissed a lawsuit that Howe filed against the Nova Scotia Barrister Society, though earlier this month, the Nova Scotia Court of Appeal reversed that decision and said that Howe can now proceed with his lawsuit against the Nova Scotia Barrister Society. Here to discuss his side of the story, the implications of all this, and racism within the provincial justice system, Lyle Howe. Lyle, thanks for joining us.
Thanks for having me.
So I want to discuss the implications of what all that means going forward, but I also want to know, I guess, how we got here. It was said that the Nova Scotia Barrister Society accused you of things like double booking clients, trying to steal clients from other lawyers, and even attempting to extort a witness of the prosecution, a crown witness, state witness. When did you first suspect or know that these claims were being made about you, and were any of them true?
So the first that I found out that I was being investigated by the Barrister Society would have been 2011. I knew that they were doing a practice review. So 2014, though, is when I actually had formal allegations by the Bar Society. So they began the investigation under the guise of trying to just help with my practice as a young lawyer. I came to find out later that that wasn't their intention, though. Their intention was to collect as much evidence as they can to try to use it against me. So
how did you, sorry to interrupt, how did you suspect that, and how did you find that out?
So initially they portrayed it like, you know, we're going to bring in some senior counsel. The senior counsel is going to help give you some guidance. But essentially what the main prerogative of the senior counsel that was looking into my practice was to just take notes provided to the Bar Society and try to find any information that they can to use against me. And so what happened was 2014, after I was initially convicted of some pretty serious criminal offenses, I got the convictions overturned. And when the convictions were overturned, that's when the Bar Society laid some pretty serious charges against me, and initiated a prosecution after I succeeded in my appeal. In terms of part of your question, whether they're true, absolutely, I was double booked, but so is literally every criminal defense lawyer in HRM at least.
So break down what that means by double booking. You're going to be in two places at once in terms of a criminal trial, consulting with the client outside of court?
No, so the main double bookings that I had were, if you go to provincial court, there's 4 or 5 courtrooms within one building. Each of those courtrooms set everybody's matter for like 9:30 in the morning or 1:30 in the afternoon. But obviously there's like a dozen lawyers and dozens of, or at least a half dozen lawyers, and dozens of people that are charged with offenses, all scheduled for 9:30. So obviously everybody's not going to be there at 9:30 and complete their matter at 9:30. So what's common back when I practiced and still today is lawyers will set 9:30 in courtroom 1, 9:30 in courtroom 2, and they'll sort of bounce between the two courtrooms until both of their matters are done. And so when I say literally every single lawyer does this, my wife's a practicing lawyer. She's commonly in multiple courts. She's never been prosecuted or charged with it. And I called, you know, many lawyers during my proceeding to demonstrate that it's common, it's accepted, judges don't have any issue with it. And I'm literally the only person that's ever been charged with it in Nova Scotia.
If everyone does it, how were they then able to successfully, you know, single you out successfully?
Well, we had an all-white panel consisting of Don Murray, who was a practicing criminal lawyer who himself is double booked in the fashion that I've been described as being double booked. We had a Crown prosecutor from the same, or a previous Crown prosecutor, retired Crown prosecutor from the same Crown's office that I laid my suits against. And then the doctor of Joel Pink. That was my 3-person panel, all old white guys. I demonstrated very clearly to them that it's standard practice and it's accepted to be in multiple courts. And they ignored that, singled me out and disbarred me, in part for that, but for other reasons too.
And so one question people might ask, you know, you're I would assume not to be the only black lawyer in the province. Why single you out specifically? So
when I started practicing in the criminal defense bar, in the private bar, I was one of the only black lawyers. I was certainly the busiest. In 2010, 2011. Now there's a couple of them. But in my bar, I was one of the only black lawyers, and I was certainly the only one that posed a threat to the status quo. I was busy, I was aggressive in terms of seeking new clients. A lot of times there's an expectation that if you're black in the criminal bar, you're either a legal aid lawyer or you're a crown attorney. And for years, this has been what's expected of us prior to my practice.
Why do you say that?
Because the private bar, there's a lot of money to be had. And there's been a stronghold on that for years from an all-white, old boys club. Okay. And so when I came in, I was a threat financially to the old boys club. And so I was the only one at that time that posed such a threat. And I think that that's in large part why things played out the way they did, with me being sort of hunted down with bogus criminal charges and then pursued aggressively with hypervigilance in my practice, and then clear, blatant double standards in terms of what I'm allowed to do versus what white lawyers are allowed to do.
And so you alluded to this a little bit. This is the second time, I guess, you were disbarred from the, I want to say, the Nova Scotia Barrister Society. No,
I can clarify that. So I was,
you were disbarred initially, but then that was reversed, correct?
I wasn't disbarred before, I was suspended. So there's a big difference between a suspension and disbarment. Okay. So suspension just means that you're not allowed to practice until the period of the suspension is over or until something changes with regard to your status. But disbarment means you're not to practice. So I was suspended when I initially was convicted of criminal offenses that I later had overturned. And then when I overturned the criminal conviction, I went back to practicing for a short time. And then they suspended me again. And when they suspended me the second time, it was in 2016, that's the subject of the lawsuit that we recently had overturned by the Court of Appeal. Right. So there's a lawyer in Halifax named Ray Larkin, and he is a partner with Joel Pink. They own a law firm together. He subsequently hired Victoria Reese, who was the head of the Complaints Investigation Committee at the Bar Society. She was essentially the primary investigator of the Bar Society that was involved with my investigation and prosecution. They're connected, obviously, because they're now in a firm together. But Ray Larkin took subject matter to the CIC in an ex parte application, which means I wasn't present during it.
I don't know what any of that means.
I'll slow it down. So when
what's CIC?
Complaints Investigation Committee.
Okay.
So there's committees within the Nova Scotia Barrister Society that can prosecute you or suspend you. And one such committee, the main committee, the CIC, decides if they want to suspend a lawyer on an interim basis, which is a very serious move, by the way. They know that when you take away somebody's livelihood and you suspend a practicing lawyer, it puts the public at jeopardy, because whatever files that lawyer has, those clients now have to go find a new lawyer who might have to start from scratch. Obviously, it's a very big step to suspend a lawyer. Okay. And it's only done if there's very good reason to do so. And it's extremely uncommon. So they went to the CIC, and essentially Mr. Larkin tried to demonstrate that I was double booked.
And what year was this?
2016.
Okay.
And so the head of the CIC asked Ray Larkin about the double booking, and he said, does Lyle represent the client that you're saying that he was double booked for? And he knew that the answer was no, because he did an investigation, and he said yes. So he deceived the CIC to suspend my license from practicing. So there's a couple things going on here. For one, the CIC would never suspend any other lawyer for being in multiple courts at once. It's a very minor thing that's accepted, common, standard, right? Not only did they suspend my practice, they did it based on lies. He knew that I wasn't double booked, and he told her point blank that I represented this client. I did not represent the client. I appeared on an interim basis, but it was another lawyer that was expected to take over the matter, and it was on the record. It was clear with the client, clear with the court, clear with the Crown, clear with the investigator, yet he lied and had my license suspended. So for that reason, I sued him for malicious prosecution and for negligent investigation. I went in front of the Supreme Court for that lawsuit on a very basic pleadings matter. I won't get into the details on it to bore you. But I ended up having my lawsuits completely dismissed by Justice Rosinski. And the Court of Appeal recently overturned that dismissal and gave me the green light to proceed with my lawsuit.
Right. And so I want to come back to that. So the first time you weren't actually disbarred, you were suspended.
Yeah.
Now, and this part is a bit touchy because you were suspended after having been convicted of, pardon me, in a very high profile case, rather. You were initially convicted with sexual assault and was giving a woman a date rape drug. So that was, you appealed that conviction.
So just a correction, I was actually acquitted of the administration of a noxious substance part.
Pardon me.
So I was never convicted of that, but I was convicted of the sexual assault initially.
So you were convicted of sexual assault. You appealed that.
Yeah.
That appeal was upheld, so it would have been, I guess, scheduled to go back to trial. The prosecution decided not to take it back to trial, so you were essentially acquitted. Well, I guess you weren't acquitted. You were just not guilty, not convicted.
Mainly the reason that the Crown Attorney decided not to take it to trial because the charges didn't make any sense. So I was charged with administering a noxious substance and sexual assault. The complainant, if we can even call her that, because she never said that I sexually assaulted her. If you look at my transcripts, she said that she doesn't remember the intercourse and that she doesn't want to remember because she knew that I had a wife and she had a boyfriend. She was very clear that she didn't want to proceed with this from the start, and she wasn't accusing me of sexual assault. So the Crown Attorney said, okay, the reason that she doesn't remember is because there was a substance that was introduced. By the way,
evidence introduced in the trial?
No, there was evidence there was evidence to the contrary. So she did a toxicology test within 12 hours or 24 hours of the time that the events occurred, and they showed that there was no substance that could explain loss of memory, or there was no date rape substance introduced, and it was clear in the toxicology report.
Was it her, though, who, I guess, accused you of sexual assault?
No.
How did it come to the police attention in the first place?
So what happened was there were condoms that were left at her residence. She didn't see them. Her boyfriend did in the morning. So her boyfriend came home, and there's actually text messages that were in the disclosure where her boyfriend said, oh, you know, looks like you had fun. I found the condoms. Her explanation was, I don't remember, obviously because she didn't want to admit what she'd done. Her boyfriend said, listen, if you don't remember, you were raped. You should take these to the police station. She initially didn't want to go. He compelled her to take them down. She left the DNA evidence with the police. It was clear to the police and the Crown from the start what was actually happening here. They didn't care. They wanted to prosecute me. So it was clear that we have somebody that regretted what they did, and they explained that they didn't remember.
So that initial conviction before it was overturned, this is why I guess you were initially suspended from the Barrister Society, because of the initial conviction?
Exactly, yeah.
Once that was, I guess, overturned is when that suspension was lifted.
That's right.
For the reason that it was overturned. What do you say to the notion, I guess, that maybe, you know, this is the reason that you were targeted the second time? Maybe racism had nothing to do with it. Maybe they just felt, well, this was a little messy and embarrassed us. Maybe it's a little bit of both.
Might be part of the reason, but there's definitely racism. And I'll tell you a couple of reasons that I know that. The main investigator, Victoria Reese, who was in charge with looking into my practice, she wrote an email to her and to the people that were helping her with the investigation. And in that email, she said that there's problems when people bring the hood into the practice. Okay.
Now, she said this to who, sorry?
She said this to her investigators that were working under her to investigate my practice.
And what did that mean?
So I asked her what it meant. And what she said that it meant, so I started by asking her her knowledge of my socioeconomic background at the time. It was little. Her knowledge of my upbringing, she knew very little. So I asked her, what did she mean by hood? And she said in cross-examination, and I've got transcripts and audios to prove this, she said that it means that you're black. And I said, so what you're saying is you perceive that there's problems when black people enter the profession? And she said, yes. So
she said this where?
At the hearing panel under oath, yes. I believe they swear them in under oath, or maybe lawyers are presumptively under oath. I can't remember. But she said it at the hearing. Audio recording and a transcript. And she said that her interpretation of her own email is there's problems when people bring blackness into the profession. I mean, to me, that's as blatant as it gets in terms of an admission of racism. And this is the person that prosecuted me and spent the Bar Society's money. It was the longest and costliest regulatory proceeding in Nova Scotia Barrister Society history. And it was very minor allegations for the most part, double bookings and stuff that's normal for other lawyers. And, you know, it's clearly racist. That's one example of the racism. I'll give you another. 2011, Daryl Pink made a memo, and Daryl Pink was the executive director of the Bar Society. Essentially, he's the head of the Bar Society. He wrote a memo to his own file referencing a conversation that he had with the chief judge of the provincial court. In that conversation, according to his own notes, he stated to Judge Curran, there's problems with a young lawyer. And by the way, this was 2011 when I was 1 year at the bar. He said, there's problems with a young black lawyer, African Nova Scotian lawyer, and I want to know if you've heard anything negative about him. The chief judge reported back only that he's double booked, or he doesn't appear in a timely fashion, but that's the case with lots of lawyers. Daryl Pink then told that judge to go to the judiciary to look for negative information about me and report it back to him. He had no reason to go on that fishing expedition. The Bar Society, by their own admission, only proceed reactively, not proactively. So they don't go looking for information. If there's a complaint, they investigate it. In my case, he identified my race, singled me out for negative stigma from the bench. And by the way, this was before I was charged with anything criminally.
So roughly what year was this?
2011.
Okay.
And I wasn't charged until 2014, I believe. So he singled me out. Sorry, the trial was in 2014. I might have been charged in 2012. Can't remember. But it was definitely before I was charged. So he singled me out, created negative stigma from the judiciary, and went looking for negative information while identifying my race.
So, excuse me. So if you have documentation of that, you have documentation of the comment that was made by the lady, I forget her name,
Victoria Reese,
with respect to bringing the hood into the courtroom. Are these the main, I guess, I don't know what word I'm looking for, but the main reasons, I guess, you're suing the Barrister Society? And if so, why was that? Why was it initially decided that you didn't have a case? So there's two parts to my claim for discrimination. One is the racist attitudes, and the attitudes are reflected in the Hood into Practice email and in the memo from Daryl Pink. The other is how I was treated, their actions. They forced me out of practice. I don't deserve to have been disbarred. I don't deserve to have even been suspended over and above 12 months in my eyes, because we have cases from white lawyers where there was dishonesty far greater than anything I was accused of, where there's a range of 6 to 12 months suspension. I was disbarred without the ability to reapply for 5 years. And what about the parts about stealing client, or either attempting or actually stealing clients from other lawyers and extorting a Crown witness? So in terms of the attempting to steal clients, first of all, it's false. Second of all, it's not unethical. So if you take somebody's, I mean, depending on how you go about it, right, if you take somebody's client, lawyers don't own clients. So you can't really steal a person. So to me, it doesn't really make sense, the allegation that I stole clients. Well,
but
what did they say specifically you did?
So I don't remember exactly what the Bar Society said that I did, because I don't believe I have any conviction for that. But essentially there was a suggestion from members of the bar that I'd poach clients. Okay. But essentially, you know, if a client decides to go with another lawyer, that's their right. Right. In terms of the intimidation of a justice participant, I beat that charge. It was a false charge to begin with. And even with an all-white panel that wanted to remove me from practice, I still beat that charge because there was no basis in reality for it. So you beat that charge. Is that separate from the you getting disbarred? Was that like a separate case? No, it was a part of what they were using to try to disbar me. So essentially they said that I intimidated a witness. The other thing I'd say is that charge stems from a racist Crown attorney named Michelle James. So if you read my... Dropping all kinds of names. Oh yeah. So Michelle James was a Crown prosecutor at the time. She's now a criminal defense lawyer. If you read my decision from the hearing panel, they themselves essentially identify her actions as racist when they drop that charge. The crazy thing to me is that she's never been suspended, prosecuted. She's still practicing, really? Despite the fact that I have 3 old white lawyers acknowledging that her actions were, I mean, I'm paraphrasing here, but they were rooted in discrimination. So to get, you know, older white lawyers to say that anybody is racist or to insinuate or infer it, really difficult to do. I accomplished that. She's still practicing without any hindrance on her practice.
So in terms of you initially not being allowed to sue the Barrister Society and then the Supreme Court overruling that, why was it determined that you weren't allowed to initially, and why was it overturned?
So Justice Rosinski was the Supreme Court judge that we went in front of for my pleadings motion. He went over and above what he was allowed to do. And that the Court of Appeal agreed with me on that.
In terms of what?
So there's a time and a place and jurisdiction for every decision that a judge can make. So the judge was supposed to be making preliminary decisions about a matter that hasn't had its day in court. We weren't at a trial stage.
They're just determining whether or not it can go to trial, whether or not there's enough evidence for it to proceed.
And the standard for that is very low. So the standard for whether you should proceed to a trial is way lower than the standard for a judge to say, oh, I agree with you and you won your case. So at a preliminary stage, he just summarily dismissed it, and there were no grounds for him to do that. He didn't have jurisdiction to do that. He tried to cut the legs out from under my case, and the Court of Appeal slapped him down for it. They overturned his ruling, and they said that I can proceed with my lawsuit. By the way, anybody who's been to the Court of Appeal knows it's extremely difficult to win at the Court of Appeal because the test at the Court of Appeal isn't, does the Court of Appeal agree with the lower court's decision? The test is, was there a legal error or a significant enough factual error or mixed fact and law error to justify a new hearing?
So you say they slapped him down, and
yeah, I mean, I'm talking colloquial here.
But where did they feel that he erred?
Well, they said that he overreached essentially. There was a motion by Ray Larkin to have my matter dismissed. There was no motion from the Nova Scotia Barrister Society or Victoria Reese, yet he dismissed it against all parties. He, when he looked at my evidence, he looked for what wasn't there instead of what was there.
What do you mean by that?
So instead of looking at the case as a whole and saying, okay, your claim is sufficient to go to trial, he picked, and he sort of in a nitpicky fashion tried to find errors in my pleadings to just justify dismissing it.
And why would he do that? Was it racism? Was it the initial criminal conviction? Or maybe you have no way of
I think there's systemic factors at play. I think that when a white lawyer is accused of being discriminatory or lying, judges and lawyers come from a small legal community where they don't like to see each other cast in negative lights, and they don't like the system to appear racist. So I think that Justice Rosinski didn't want to see my case go to trial, didn't want to give me the opportunity to potentially win or for this evidence to come out and to be heard. So he just tried to cut the legs out from under it before it could get there. And I think that that's a common trend in Nova Scotia, in the criminal justice system. It's the decision makers are mostly white, and they wear blinders when it comes to racism. They want to ignore it, act like it's not there, and sweep it under the rug. And I think that Justice Rosinski's actions were an example of that, but I can point to plenty more.
You're not able to, I guess, sue him for that, I would understand.
I don't think I can sue him, but I could put in a complaint through the criminal justice or through the judicial complaint committee. Right. But it's really difficult to sue a judge because they have immunity and they have protections within the legislation that protect you from being able to sue them like you could a regular person. Right. Their decisions are protected.
So you've talked about racism, systemic racism in this instance. You've talked before about racism with respect to the courts, prosecution, sentencing, jury selection. And correct me if I'm wrong. You've argued that there should be more black professionals and I guess jury members in positions of power like this. But isn't it also true, I guess, that not all black people think monolithically, I guess, as they say, or are in agreement about how racism and white supremacy operates? Is there a danger of just saying, okay, put black people in these positions of power, in the legal profession or any profession or workplace, who might just then uphold or if not double down on the status quo? Aren't we in a worse position if we just say put more black people in those positions and then it's all solved? It's
an excellent question. The first thing I would say is this: any individual white person might make a better decision than any individual black person. Right. So I'm not prejudiced to the degree that I think that just because you're white, you're going to make a negative decision against me. But here's what I would say. If somebody were to walk through the door and I don't know anything about them, if one's black and one's white, I'll take the white guy, I'll take the black guy as the decision maker if it's something that affects me or my life. And I'll tell you why. I think he's more likely to be compassionate for me. He's more likely to see me as somebody that's like him or his child. He's more likely to come from a background where he can appreciate my decisions. For 300 years, white decision makers have let us down. We've been overly prosecuted, overly incarcerated. We're underrepresented in legal profession, and pretty well every other profession. We're largely underrepresented.
And it's statistics to back these things up. You're not just...
Well, no, I mean, I'm not a statistician, but I think that you can, you could ask any professional and they'll tell you we don't have enough black lawyers, dentists, judges. And so
that there are, I think, I don't have them in front of me, but statistics that do back up some of these things in terms
I think so. But here's one thing that I would point out. For 300 years, I think everybody would agree with me that when black people leave themselves in the hands of white people, white decision makers, doesn't work out, right? So if you look at Africville, and not just black people, look at the indigenous school systems, look at pretty well any decisions that are made by white people historically have been bad for us mostly. Okay. So when I say that I want, more black judges, more black jurors, I think that, first of all, we should be represented. The system should appear to be fair. But also, if it's me, I'm very rarely, if ever, persecuted or prosecuted by black people. It's normally white people. And the other thing that I would say is this. In terms of jurors, I talked to a white lawyer the other day who's actually a friend of mine. He should remain nameless right now, but I asked him, you're white, okay? If you had and he's done criminal defense work. If you had a black client, would you want black people on your jury or white? He said, I'd want black people. I would take black jurors every time because he knows, white people know, that black jurors and decision makers are less likely to be harsh on black people than white jurors. And when you go through these juries, it's essentially all white jury after all white jury prosecuting our young people, making decisions with respect to our young people and incarcerating them.
I'll throw you a little curveball. Some people might hear that and say, well, you're saying that black people will give black people a pass, maybe, even if they are guilty.
I'll go further.
What would you say to that argument?
I'll go further than that. I asked that same lawyer, if you had a white client, would you rather an all-white jury or would you rather black people on that jury? He said he'd rather black people on that jury. Okay. I think that white folks are more, in general, they're more likely to be...
assume guilt, maybe?
No, I would say that they're more likely to be by the book. Okay. They're perceived that way even by white lawyers. So I think that they know if we get people that are from the black community, we're more likely to say, oh, I'm going to question the police authority. I'm going to question the actions of the Crown. I'm going to be more charitable with my interpretation of the actions of the accused. And I think that, obviously there's exceptions to that. The thing that I'll point out about the exceptions, which is another part of your question, what if we get people in these positions that are black, but they're not right for that position, or they're not?
Well, even if they have good intentions, maybe, if the status quo is as you claim it to be, it would be rather intimidating to come in there and say, okay, I'm going to do things differently than they've always been done. Or maybe some folks are eager to want to do things the way they've always been done so that they can advance.
Here's a problem that I've seen. The black people that tend to rise the ranks and become managers of Crown attorneys, like higher positions in the Crown attorney's office, or the ones that recently have become judges, one in particular, I find that they tend to be people that are not pro-black, because the people that are putting them in these higher positions, the powers that be, they choose black people that aren't actually going to benefit black people.
And so get back to, I guess, my initial question then. So if we just put black people in there, is there a danger in them saying, okay, you got what you wanted, stop complaining about the racism?
There's a danger if we keep letting the powers that be pick people that look black but act white against us.
So then what's the solution?
The solution is to have more black people in positions so that eventually It's not all old white guys that are making decisions on who becomes judges, who becomes high-ranking crown attorneys, and managerial positions and hiring positions and so forth. I think that it will change over time just by having numbers. And I think that, I hope at least, and I'm fairly confident about this actually, there's less people that are going to hurt us that are black than that are going to help us. So if we put numbers in there, I think we'll get some people that do the right thing. The other thing I'll point out is this. In 2016, when I had my conviction overturned, might have been 2015, at that point there had never been a Supreme Court justice that was black in Nova Scotia or a Court of Appeal judge that was black in Nova Scotia. Since then, there's been a couple that were appointed, and I called them out extensively. Anytime somebody puts a microphone in front of me, I would point out how few black judges there are. There's been quite a few lately. The courts are getting better at being representative of African Nova Scotians. So much better. So
if I'm hearing you correctly, you're not optimistic that it's going to be a quick fix solution, I guess.
No, I think that it's already improving. It's already improved pretty drastically in terms of the numbers in the courts, but that's just one part of the problem. I mean, jury selection, jury pools are an issue. I know if you look into the public prosecution service, there tends to be issues there in terms of their hiring practices historically, and I know that they've got some work that they've got to do there. But you know, right across the system, there's systemic discrimination, and there's individual actors who are blatantly racist. I've exposed them for being blatantly racist, and the system not only gives them a pass, it helps them perpetuate systemic discrimination.
So you mentioned the public prosecution service. I'm not completely up to date on the details, but I know they have some announcements that are coming out with respect to I'm not even sure racism in the justice system. We saw the Nova Scotia Court of Appeal uphold the use of impact of race and culture assessments when sentencing black people of criminal convictions in the province. We've seen both the former provincial Liberal government and the current progressive Conservative government commit to funding for the African Nova Scotian Justice Institute, and we've had members of the Justice Institute here on Community Update. We've seen street checks banned, and an amendment added that made it so that police need to have reasonable suspicion when questioning members of the public, white or black, theoretically eliminating, unconscious bias for police when determining, whether or not someone seems suspicious. And so maybe you answered this already, but you would agree, or would you agree or disagree that there's progress being made? Is it enough?
No.
Is there what's lacking?
No, there's progress being made for sure, but it's not enough. I mean, when somebody can be declared discriminatory as a lawyer and still practice without a suspension or any kind of a prosecution, that's not enough. When a lawyer can write the hood into practice email, admit what they mean about it, investigate a lawyer for years, and go back to work the next day like nothing happened, that's not enough. When the appointments that are made include people that clearly have a history of perpetuating rather than eliminating systemic discrimination, that's not enough. I mean,
you're talking about black judges.
Yeah, I mean, I'll name them if you want.
Well, I just want to be specific. That's what you mean.
Yeah, I'm talking about Perry Borden. I question that appointment just based on my personal interactions with them. I mean, I've got a transcript where I can demonstrate that, if anything, he's helped perpetuate systemic discrimination rather than eliminate it. And I mean, I'm quite comfortable with pointing out sort of 1,000 different ways that the system is still working against us. There are some ways that it's improving, though, like the work that Robert Wright does with the impact statements and the work with the the African Nova Scotian Justice Institute. That's incredible. Like, I'm really impressed with what they do. Two of the people that run that I went to law school with, Brandon Roll and Dave Curry, and I know that those are great men that do the right thing.
And what specifically have they done that you can point to say, okay, that gives us hope?
So they represent people for free. Right. They get funding from the government, and they can take whatever cases they want to address discrimination. I mean, that's huge.
And they were the ones who, I guess, were involved in the race of impact and culture assessment. So.
I think, Brandon Roll was involved with that, but also Robert Wright. But the work that Dave Curry and Brandon Roll have been doing is massively commendable. Think about a system where not only can you pick cases that you want to help people, You do it for free and you're funded by the government. That's a major step towards helping Black people address systemic discrimination.
And so with respect to, I guess, racism in the justice system, what should Black people in this province be concerned about? What should they, if people are hearing some of this stuff for the first time, or if it's causing concern, what can or should they do to, better educate themselves about how some of this stuff works, or to double check some of what you're saying?
I'll give you some specific things that they should look out for. If you're in Judge Murphy's courtroom in Dartmouth Provincial Court, you're in a courtroom where it's presided over by somebody who a Black lawyer has alleged was discriminatory. Yes, I think that Judge Murphy is discriminatory in her actions. And if I had any Black relative or friend in her courtroom, I would say you should be looking for a different judge.
Why do you say that?
So she singled me out in a major way. I was in a courtroom where, I'll back up. On summary and preliminary matters where there's not actual evidence being called, it's normal for a senior lawyer to send a junior lawyer to appear as their agent. So the junior lawyer would go in and speak to the matter on the record and deal with minor things, setting dates and stuff like that.
When you say a junior lawyer, is it someone who's not a full lawyer yet? Or
no, they're a lawyer, but they might have less experience than the senior lawyer.
But they're entitled to be there.
They're entitled to be there. They're a practicing lawyer. So routinely, in Nova Scotia and beyond, senior lawyers or even junior lawyers will send an agent to appear on their behalf if they can't be in a courtroom for something minor, right?
Okay. Something minor
like we're setting a date, or we're confirming whether there's a charter application being made, or there's no witnesses there. We're just dealing with housekeeping.
Not an actual trial.
Exactly.
Like okay.
It's normal for agents to appear, okay?
But they have to be a lawyer themselves.
Normally.
Okay.
In some circumstances, they could be an article clerk or something like that.
Okay.
So Judge Murphy presided over a matter where there were 3 agents appearing on the record for the principal lawyer, okay? One of the lawyers that appeared was Pavel Bubnov, who was there as my agent. So I was the principal on the file. Pavel Bubnov was the agent on the file, okay? Immediately, Judge Murphy noticed that on the record and took issue with it, even though it's normal for agents to appear for principals. So she said, "Where's Lyle?" Because she noticed that, or "Where's Mr. Howe?" Because she noticed that I wasn't there. Mm-hmm. She asked Mr. Bubnov to go and retrieve me. I was in Halifax Provincial Court. He was in Dartmouth. I left Halifax Provincial Court. I drove to Dartmouth Provincial Court. And as I was getting to court, Judge Murphy wanted to go on the record because she wanted to criticize me for not being there. And she wanted a record of it to send to the Bar Society. So she said to me, essentially, "You're supposed to be here. You're not supposed to send an agent. Why? You're always supposed to be here. It applies to everybody." And then I pointed out that the other 2 white lawyers that were there were agents appearing for white principals. But she didn't notice that because she was fixated on trying to find fault with me.
Well, maybe she was, like you say, fixated on you. How do we know that that's racism? Maybe it's just a personal gripe with just you.
So the way that racism works nowadays...
Whether or not that's right or wrong.
The way that racism works nowadays, you can always say that. But we still have to draw inferences that are reasonable. Okay. So if you look at, there's 2 white lawyers. So there's 4 white people, okay? 2 white agents, 2 white principals, 1 Black lawyer. Maybe she only noticed because I was Black. That's a problem. Maybe she noticed because she's biased against Black people. That's a bigger problem. Maybe she noticed for some other reason, like there was stigma associated with my name. You shouldn't single somebody out more just because there's stigma associated with them. You shouldn't treat them differently and create more stigma because there's already stigma that exists. But let me back up for 1 second.
But if I was going to say, if I have a trial coming up, I've been charged with a criminal offense, and I see that I have Judge Murphy coming up, am I able to apply for a different judge? I mean, it doesn't seem like there'd be much I'd be able to do. So, if anything,
you can ask for a recusal. And if you make an application and you base the recusal based on what I've just described, I'll give you my evidence. You can have my transcript where she singled me out and it was clear that it was discriminatory double standards that were being applied. The African Nova Scotia Justice Institute, maybe they want to take this on and make it so that she's recused off of matters when it's Black people. We can fight it. We don't just walk in the door and accept it. That doesn't mean she's just going to say, "Okay, you want a different judge, go ahead." It might be a fight, But what I'm saying is you should fight.
And so did you complain against the
judge? I
Oh.
put in a complaint against the judge, and I'm currently working on my complaint, the next stage in the process for trying to do something about that. But, it's a difficult process. The other thing I would say is this. Racist people don't just admit that they're racist today, right? Maybe 40, 50 years ago it was socially acceptable to do so. Nowadays, if she admitted that, oh, I did this because Lyle's black, she'd be off the bench. She's not that stupid, right?
Exactly.
So obviously, every single time that we encounter modern racism, they could try to point to something else, right? My cousin, Shane Howe, years ago, had a cross burnt on his lawn, which is one of the most obvious examples historically of racism. That's, and even during that,
from my recollection, two cousins of his partner were charged and convicted of that.
Exactly. But even then,
these were white people.
Right. But if you ask them, they'd say, we weren't racist. We just had a personal problem with him. You burnt a cross on his lawn. That's as obvious as it gets that it's racially motivated, right? So I think that...
But they were convicted, weren't they?
I think they were convicted. I'm pretty sure they got a slap on the wrist. But my point is, modern day racism consistently is going to be, oh, I did it for another reason. Not only modern day racism.
Even when it's blatant, you're saying.
When it's blatant. So if you look at the historical record. Exactly. If you look at the historical records from executions in Nova Scotia, one of the earliest ones from like the 1700s was a black woman from Africville, that was executed for stealing potatoes, right? Okay. And so if you went back to the 1700s, even those people would say, we're not murdering you because you're black. There's other black people that we're not murdering. We're killing you because you stole potatoes. That's what modern racism looks like, right? We say, look, we disbarred you because of the double bookings and because of your language associated with the double bookings. You lacked candor or whatever. That's like pointing to the potatoes for that black woman. You just want to hang her. They just wanted to lynch me. And with Judge Murphy, she could try to point to whatever she wants to, why she didn't notice the other two white lawyers, but she noticed me. But I know in my heart that it has to do with my race. And I know that all of the stigma that I've encountered is connected to my race. I was charged with uttering threats one time and accused of swinging through the bars at an inmate. This inmate had dozens of convictions for fraud. The police took his word over mine, didn't even look at the video in the cells, and charged me. Yeah, white complainant, and charged me with uttering threats, despite a video that shows that he was lying about what happened. Prosecutor didn't even bother looking at that video, proceeded against me for months, okay? Then finally, when I pushed for the video, they dropped the charges after they put me in the paper and accused me of swinging at somebody and threatening people. They charged a lawyer based on the word of an incarcerated fraudster with many fraud convictions. I know in my heart, the police officer can try to say I was just doing my job. No, you aren't. You wanted to try to smear my name through the mud, and part of it's because I'm black. And I know that, whatever excuses the system wants to try to point to as justification for their actions, we need to draw our own inferences. Yeah. Just like we would draw an inference about the lady with the potatoes, we don't even need to be in 1700 or hear the evidence. We know that no white person's being hung for potatoes.
That's what I was thinking. Maybe there was. I don't know. I'd have to go back.
No white person's being hung for potatoes. No black person's being disbarred. No white person's being disbarred for double bookings. They're not even being prosecuted for it. No white people are being charged with swinging through the bars if there's a video that shows that he didn't do it. I got a lawsuit pending for that, by the way. No white lawyer would be treated the way that I was treated. And it was dozens of different interactions and several different institutions. So I have problems with how the police how the police investigate black people, and based on my own experience and my professional experience. I have problems with how public prosecution proceeds against black people. The sentences tend to be harsher against black people, in my opinion. Right across the board, black people are overly investigated, overly prosecuted. They're pushed out of their profession at a higher rate, at least in my anecdotal experience. I feel that. And I feel that our system is broken. And so we have some people trying to repair it, but it's not enough.
And you seem to have, countless specific examples of how, I guess, anti-black racism and systemic racism work within the justice system. I suspect you probably have more if we had more time.
I could talk to you for a month.
But
this is just my personal experience.
Right.
Once I start to get into my professional experience on what my clients have encountered, like in terms of how Black people are treated by our system, it's far harsher than white people. And I could give you countless examples of that, but I think that other people have already spoken on those issues.
Yeah, and I mean, we can come back and get into that, at a later date.
Yeah.
Again. But let me just, to close it up, I guess, bring it back to this recent decision that said that you can proceed with your lawsuit against the Nova Scotia Barrister Society. Where are we going with that? What do you hope to happen? What do you anticipate will happen? Do you want to practice law again? Will you be practicing law again? Where are we going with it?
So I'll break down a couple of those questions. First of all, the significance of that decision is huge, because now I can go and do a discovery, which gives me wide latitude to get documents from the Barrister Society and from the lawyers that I've accused of being discriminatory and being malicious. It gives me an ability to really dig into information that I otherwise wouldn't have access to.
And so they will now, if I'm correct, have to testify under oath if you say so?
They have to answer all my questions, and they have to demonstrate that my questions are unreasonable or otherwise inadmissible. But other than that, you better believe that I'm going at them.
Do you have any questions that you'd be willing to share right here that you think are
not just yet
bode well for them?
Not just yet, but I can promise you this. I'm going to do anything in my power to get as much details that will help my argument as possible. And I think it's going to help not just me, but others once I start digging and I demonstrate how racist these people are.
What about your disbarment? Is that automatically, is that gone away, or do you have to apply to?
So I'm in the process of doing a rescind application. So a rescind application, I can go in front of the hearing panel that initially disbarred me and demonstrate why they should change that sentence to something less than what they initially sentenced me to. So what I have going on right now, since I was disbarred, 3 right lawyers were sentenced through the hearing panel for dishonesty, stealing money or misappropriating money or mishandling of funds, something along those lines, and blatant instances of dishonesty that are far more serious than what I was accused of in my mind. And I think I can demonstrate that to the panel. So right now I'm going in front of the panel and I'm saying, look, the range of appropriate sentences is between 6 and 12 months if you accept my facts, right?
And how long has yours been?
I've been disbarred for 7 years. So my goal is to get my sanction reduced down to something more appropriate, 12 months perhaps. And then I want to be compensated for the rest of the time that I was unable to practice.
And are you confident that that's going to happen?
Not with our system. You can never be confident with our system. Our system is broken. I believe that that's what should happen, and I'm going to fight tooth and nail to make it happen. The good thing about this is the following. I can guarantee you that I will fight this until I die if I don't win. So even if I lose this rescind application, I take the rescind application and I go to Court of Appeal or judicial review. If I lose that, I go to the Supreme Court of Canada. If I lose that, I do another rescind application, because in Section 44 of the Legal Profession Act, it doesn't limit my ability to go question this decision. So right now we have 3 white panel members, and trust me, I don't want them on my panel. I tried before to get them off my panel. I'd love to have some ethnicity on my panel, or even a female on my panel, or even different panel members that are white other than the ones that I'm in competition with and that I've sued their pension provider. I'm going to fight this until the day I die. If I win that rescind application, I take that to a lawsuit and I say I want my economic loss for the years that I was removed from practice unfairly. If I lose, I go to the Human Rights Commission and I say, look, this is a further instance of them discriminating against me. I still got 2 other human rights matters pending. The Bar Society is going to be tied up in years worth of litigation amounting to millions of dollars if they don't do the right thing. And I think that they know that I'm going to fight this thing until I die. And one of the things that's good, my issues happened when I was so young. Like I was in my 20s when this stuff started, right? I'm 39 years old. Most of the people who are my oppressors are a lot older than me. They're old enough to be my mother. So once they start to lose their positions, and a lot of them already have, Victoria Reese has already gone from the Bar Society. Daryl Pink's already gone from the Bar Society. I'd like to think that it's tied into my issues. I don't know one way or the other. But one thing I can tell you is they're older than I am. These panel members, I hope that they're not going to be on the panel until I die. And hopefully I'll get a fresh set of ears at some point that's going to listen to these things and stop looking at it with blinders and ignoring this blatant discrimination that I'm putting in front of them. So practicing right now is not my number one priority. I'm quite busy. I have 3 kids. These battles that I have take up a lot of time and energy. My number one priority is to rectify the wrong. And that doesn't mean give me my license so I can go to court today. That means fix the problem that they've created. To me, I'm owed millions of dollars, years of my practice, an extreme amount of stigma that I shouldn't have had to gone through. I was wronged. It was a discriminatory prosecution. I connect the Bar Society with the Crown's office, by the way, and watch this. So the head of the CIC who investigated me, that drafted the Hood into Practice email, her name is Victoria Reese. At the time, her husband was the head of the Crown prosecution, of public prosecution. His name was Martin Hirschhorn. Neither of them are in that position anymore. So think about that. I get prosecuted by PPS, right? And I'm arguing that they're discriminatory. Okay. I get prosecuted by the Nova Scotia Barrister Society, and literally the lead prosecutor from each are married together. So if that doesn't connect my matters, then I think we're blind to how the interworkings of systemic discrimination actually apply. These people that are in power, they're in bed together, and they work against us as a system.
So clearly, we haven't heard the end of this. It's going to be perhaps a part 2, 3.
Yeah, listen, I'm happy to come on as much as you'll have me. I appreciate the opportunity to speak with you about these things. Obviously, we're talking about 12, 13 years worth of my life. So to try to fit it into an hour is pretty difficult. So I would love to come in and tell you a bit more about the problem as I see it.
Well, I suspect there'll be a lot of people have a lot of things to say about just this past hour, but I do look forward to getting back into this with you, Lyle, and I thank you for joining us.
Thank you very much, Matthew. I appreciate what you do.